Good morning. Are you Jeremiah Branch?
Yes, ma'am.
Good. And Mr. Branch was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1382 and 1385. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir. Yes, sir.
Any additions or corrections?
No.
All right, Mr. Branch, I am going to find that you entered your plea of guilty in each case freely and voluntarily. In cause number 25 DCCR 1382, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions. And I'm going to go over some specific ones in just a minute. And then in cause number 25 DCCR 1385, also find sufficient evidence to find you guilty, but follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You will also be ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. A couple of specific things that you're going to be required to do. One is to enter and successfully complete the JCDI program. That's an outpatient intensive program for drug treatment. So it's to be able to give you the tools to stop using whatever drugs you're using, stay clean so that you can be successful in your probation. Also, I know you've already gone and I think have some relationship with Spinal Talk, and you're going to be required to continue all of that. That's part of your probation. Obviously, that's something that you need to make sure you also can be successful, okay? If you do everything you're supposed to and successfully complete these probations, this is an excellent opportunity today because you do not have these felony convictions on your record. And at the end of the probation period, if you're successful, the cases will actually be dismissed and you'll never have convictions on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty in each case, and you could be sent to prison for anywhere between 2 years and up to 20 years. Do you understand? All right, in each of your cases, I'm handing you the trial court certifications. That shows that these were agreements that I followed, and so you have waived your right to appeal. I will sign dismissals in cause numbers 25 DCCR 1383 and 1384 as part of that plea agreement as well. All right, good luck to you, sir. You can go back with the bailiff.
Right. You just want to reset.
Yeah. You're not the one that Tommy wanted to letter. Go over everything.
No. Just an order.
Say Ruth Stewart, Mr. Kimler.
Yes, sir. That's the one we have the report from Tom. So. Talked to her at the jail, so she's still pretty. The report's in. She's. I don't think they're gonna be able to rush more in 30 minutes. Last time she had to get a big experience for a year before we could figure it out. So we'll see if they can do 30 days. I'm not optimistic.
There's no 30-day.
I thought that they kept her for 30 days.
Kept her where?
HCPC over at Harris County. That's where she goes. That's what happened last time.
No.
The first one's up to 120 days.
Yeah.
The second one's up to a year.
Yeah, that's, she had to do the second one last time.
All right, and are you Ruth Stewart? This is cause number 25 DCCR 1692. I'm going to take judicial notice of the court's file. It includes an evaluation that was prepared and done by Dr. Hamza regarding competency to stand trial. That report is dated December 16th of 2025. And the finding in that report is that Ms. Stewart is not competent to stand trial. Is there any other evidence with regard to competency?
None from the defense, right?
All right, then based on that report, I am going to find Ms. Stewart not competent to stand trial, order that inpatient treatment is required for competency restoration, order that she be sent to the appropriate facility for a period of not to exceed 120 days from the day she gets there for competency restoration, and then we will await a report from whatever facility that is. All right, you can go back with the bailiff.
Now, a month.
Yeah. you've got a Naomi Kidd, Naomi. It's a sentencing.
You want to, I think we could probably,
If you'll give us just a second on the kid, I
He
think
has
we can
several.
get something worked out. He's got a total sentence that he served in.
That's what I was wondering. I have a note wondering what the status of that
We're
was.
just trying to get him revoked.
Okay, all right, I'll just, hold it while y'all take care of that.
kids.
We're gonna hold him for a minute.
So,
See, Mr. Matuska on Raul Karina. Morning.
Good morning, Your Honor.
Morning to everyone other than people who are leaving us. No.
Where you going?
Kidding.
City Bar?
Couple more blocks.
Down more stuff on? Yeah. The Kevin Lane file?
Good morning. Are you Raul Carino? And Mr. Carino's case is set for trial to begin with jury selection this coming Monday. And what is the announcement?
Your Honor, the state is ready for trial, although there's a witness that I really do need to put on our case and is unavailable for trial. So,
Well, you can't be ready and need a witness too. So either you're ready or not.
we need that witness, Your Honor.
Okay.
It's the lab animal, DNA lab animal.
Okay. And she'll be out all week.
What she told me was she was unavailable to travel and testify this coming week.
Mr. Matuska?
Your Honor, I spoke about this already with Mr. Nichols, I understand.
Okay.
And whatever scheduling that needs to be done, I can accommodate the court.
Okay. Obviously, since Mr. Carino's in custody, I want to try to get it tried as quickly as possible. I'll reset it off of this trial docket to the next available trial docket. If there's any change, and that's obviously before any change that's going to take place, just let me know and we'll get somebody that can jump in as quickly as possible. Mr. Carino, I'll get your case set as quickly as possible, but I'm going to give the state one reset so that they can try to get that witness, okay? All right, you can go back with the bailiff.
Thank you, Your Honor.
Yes, sir.
And what you mentioned to me yesterday would be an issue. He's got a
Oh, he does? Good. Okay, so we'll have to
and
work.
his behavior in the jail, so I can motion for increase that.
Okay, good, perfect. Don't have to have an issue. Michael Victoria, Mr. Smith and Mr. Matuska. This is the one you were saying that's so old for some reason, yeah.
I haven't been on it too long, I don't think I got November.
Yeah,
Yeah, he was in federal custody for a long time.
and we just forgot about it, decided not to indict it, or
No,
not
it's
get him?
been
We just didn't go
indicted
get
since Bob
him?
was here, I guess. I mean, it was in the bottom drawer.
All right, so you're Michael Victoria? And Mr. Victoria is charged with murder in each of cause numbers 21-36410 and 21-36411. And what is the announcement?
Your Honor, I plan to file a motion for trial this week on this. There's quite a bit of evidence. I've talked to Mr. Smith. I'm going to provide that to whoever's needed, but first I need to file a motion.
Okay, so Mr. Victoria, Mr. Matuska is going in a different direction, and so he's going to have to file and get off of most of his cases over here. So what I'll do is we will have somebody prepared this week to appoint as soon as he gets that filed, that can get kind of caught up. I know there's a lot of discovery. Mr. Matuska is going to get that to the court. We'll get that to whoever we appoint, and they'll begin preparation real quick and be out to see within a week or so. Okay, you can go back with the bailiff. No, he'll file on that one too, because it's gonna be on the next, it'll be past the time, yeah. because he's appointed. I don't think so. Yes, that's a good question, though. So, Mr. Kimler, I have a note here. Were you hired on David Greer?
Yes.
Okay. Are you ready
Got
to
an
announce?
offer. I was gonna discuss the offer with you.
I'll hold it. Mr. Parker, you have Maria Gutierrez. Oh, I don't have it yet. Let me recall it in just a minute when it's ready. Where did it go?
Mr. Mayor, this has a motion. This was sent last night. I just want to bring that to your attention.
Okay.
Hey Sharon, they're doing paperwork.
Do I need to do something?
No, just, it's right in the middle of the middle.
Yeah, I can swear that.
I don't know if it's even come through. Do you see Maria Gutierrez stuff?
I'm doing it right now, Judge.
Oh, okay. That's okay. It's all good. Mr. Parker, on Jacoby and Dorsey. Go ahead.
I don't think that even matters.
I did that.
TRN.
It's a rejection, Judge.
Yeah, here's county.
Mr. Coleman, yep. Good morning. You're Jacoby and Dorsey. And Mr. Dorsey, in cause number 25 DCCR 1896, you're charged with a second-degree felony offense of manslaughter from November 17th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in the institutional division of the Texas Department of Corrections.
Your Honor, it's my understanding he has a prior felony conviction that's enhanced to a first.
That is the way, well, it's not indicted that way, Judge, but I will be seeking a repeat offender. I'll be filing a repeat offender notice.
I wrote first degree on there.
Right.
Because, and there's some confusion. He also explains that his underlying conviction is on appeal, I believe. That's what he tells me. So I told him I would check with the court to make sure that's right. It was 5 to 99 or 2 to 20, because I didn't know the status of all the other stuff.
If it's on appeal, then potentially that could be an issue with regard to it being a final conviction. So what can happen is if that appeal, once it's complete, and if they affirm that verdict and that conviction, and at that point, this would then potentially become, for punishment purposes, enhanced to a first-degree felony if that conviction becomes final. And I don't really know, the final conviction date, if that creates an issue because of the appellate process.
I'm not sure, Judge. I'm gonna have to look at it.
Judge, and I don't know the answer to that question.
Yeah.
But being familiar with this defendant, I tried him next door, involving several co-defendants. Ms. Duchamp and I did several years ago.
Okay,
He actually was on probation over there for cooperating with us for aggravated robbery involving an adjacent murder. He received 30 years on that revocation. I went back and double-checked, and I'm sorry to interject, double-checked that date. That hearing and that revocation was before this offense date. He had actually gone to Jefferson County Jail and was waiting on his 30-year sentence at TDC when this offense occurred in the jail.
And with that being said, Judge, the state will also be seeking, to the extent the law will allow us, to stack any sentence in this case on top of that 30 years sentence. He received.
He's
But-
already filed the paper for that.
that 30-year sentence, though, is the one that is on appeal.
Possibly on appeal.
Okay, so I guess
If it's
that's
affirmed,
the
I
question.
think our position would be that the decision that was made that was then subsequently.
It would go back to the
affirmed would go
conviction
back to
date.
that date, yes.
That would tend to be what I would think, but we would obviously have to do a little bit of research to double check. And so I think that the most thorough way to do this is for you to understand that if that conviction is affirmed by the Court of Appeals, then it would appear that the conviction date then goes back to when that original conviction was, which was prior to the date of this offense. And therefore, it could enhance your punishment to that first-degree felony. If you go to a jury and they find that you're guilty and they find that conviction true, which means your minimum punishment would be 5 years instead of 2, up to 99 years or life in prison. Do you understand? In addition, if it's affirmed prior to any trial date or anything like that, and you're found guilty, Mr. Coleman can ask that any sentence that a jury gives you be stacked on top of or run consecutive to that 30-year sentence.
He's already filed that paperwork, Judge.
Okay, and that decision would be up to the court or up to me. So if you're found guilty, that could be a potential punishment in addition to yours, is that whatever the jury gives you, I could stack on top of that 30-year sentence. Do you understand all of that? I'm sorry, speak up. And I have a plea bargain rejection that you've signed here with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on just the count of manslaughter itself for a 20-year term in the institutional division. And that would be to run concurrently, that would be stacked.
That would be stacked, Judge. At least that's the offer as it stands. The state will entertain a counter offer.
Well, I mean, that's,
I
okay.
get it, Judge.
I can't, don't know why anybody would
No, I
accept
get it.
that offer. So, do y'all want to visit a little bit more about this?
I can
and
talk to him
before
to
I
see
put
if-
it on a trial
I
docket?
can talk to him about.
Let me hold it.
possibilities.
Y'all visit a little bit about that before I take this
Okay.
to the trial docket. Ms. Perazzo, you have Jose Lopez Pamias? I think. Good morning. Good morning, sir. How are you? Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
I do.
Thank you. Thank you for being here.
Peachy. Are we still in our respective corners?
Good morning. Are you Jose Manuel Lopez Pamias?
Yes.
And Mr. Lopez Pamias has 3 cases of aggravated assault with a deadly weapon, all set for trial to begin with jury selection next Monday. And what is the announcement?
We're ready, Your Honor.
State's ready, Judge.
Has there been any change in negotiations or offers or anything like that?
No, ma'am.
No,
It's all the same.
And that was,
And I believe that the last offer that was rejected was the state was going to forego.
hold on.
I'm so sorry. So sorry.
If you'll just tell him to, I'll give him an opportunity to ask questions if he needs them in just a few minutes. Okay.
Sorry.
No, you're good. Thank you. Go ahead.
Okay. The last offer that was received from the state was that in exchange for Mr. Lopez Pamias pleading guilty to all 3 cases, that the enhancement paragraphs of the indictment would be dropped and he would just go forward on the 2nd-degree felony, the first paragraph of each indictment, and go to punishment, go to the court for punishment, which would have been within the 2 to 20 range. However, he rejected that offer. He was advised that he was habitual and that if we proceeded to trial and if he was found guilty on any of the cases, either indictment, that his punishment range would be no less than 25 to 99 to life. And he insists on going forward and rejecting that previous offer.
Okay, and you have visited with him about all of that with an interpreter and feel like he understands the options and consequences of going forward with trial next week?
Multiple times, and Ruben can back me on that.
Okay, and so you've been the translator with regard to those meetings?
Correct.
Okay, and do you have any reason to believe that Mr. Lopez Pamillas does not understand the situation or what Ms. Perazo has informed him about?
No, Your Honor.
Okay, thank you for that. So, Mr. Lopez Pamillas,
So,
I want to make sure you understand, your case will be set number 1 for next week, and I will not accept plea agreement after today. So if you're found guilty by a jury next week, and they find those prior convictions true, your minimum punishment would be 25 years, up to 99 years or life. Do you understand?
Yes, I do, understand.
And do you want to go forward with trial next week?
Yes, for sure.
Okay, and Mr. Coleman, what is the state's position with regard to, have you filed a motion to consolidate the 3 cases or no?
I have to check.
You have, I see it.
Okay.
It's been a while.
Yeah.
And is it your intention to do that since they're all out of the same, I guess, episode?
Yes, Your Honor.
Okay, and you wouldn't have any objection to that?
No, Your Honor.
Get 'em- Okay, all right then, I will number the
I'm
cases.
sorry, Your Honor, he says he has a question.
Yes, sir.
Supuestamente la corte, a mí no me han movido de la máxima, de la máxima. Esto es un castigo de 72 horas y yo llevo 10 meses.
Supposedly, I've been in custody for months. I thought,
Let him tell me.
okay. I've been in maximum, I guess, he says, holding for months now, and he thought he was gonna be moved by now.
I don't have any say-so over the jail or where they hold you or what classification you're given. I can't tell them where to put you, that's up to the jail.
Ellos dijeron que la corte y la administración dijeron que yo tenía que estar ahí.
The court said I had to stay there.
No, I didn't say, that's not true.
Okay, exacto.
No es verdad.
Okay, we'll see you next week, okay? You can visit with your attorney about that.
Okay. Ahorita podemos-
We'll get your case trialed next week.
Okay. Yes, sir.
Mr. Radford, you have Nevada Bates.
Yes, ma'am, that's gonna be a trial.
Did you do a rejection?
It's already done.
That's what Luke told me.
We're doing a rejection back in October, Your Honor.
He got a new state jail felony. That doesn't affect the offer.
Good morning, sir. Are you Nevada Bates? And this is cause numbers 25 DCCR 0834, 1698, and 1909. Mr. Bates is charged with aggravated robbery, possession of a controlled substance, and obstruction or retaliation. And Mr. Radford, what is the announcement?
Judge, I have talked to Mr. Bates about his case and he wants to sit up for trial. Is that correct, Mr. Bates?
Speak up, please. And so, Mr. Bates, it looks like back in October of last year, you were here and you signed a plea bargain rejection where the district attorney's office made an offer of a cap of 25 years. in that aggravated robbery case, which means you would go to, can I get y'all to hold it down, please? Hold it down, please. Which means if you wanted to take that deal, you could leave your punishment up to the court, and I could give you 25 years, I could give you less. It would just depend on the information that was brought to me. Again, you've got every right to reject that, and is that what you want to do and go forward with trial?
Yes, that's true.
Okay, we will get your case set on the next available trial docket. Mr. Radford will begin preparation. All right, you can go back with the bailiff.
Judge, may I be excused?
Yes, sir.
Thank you, Your Honor.
Thank you. See, Mr. Rojas, you've got Keisha Lewis. You've got Keisha Lewis.
Yes, ma'am, I just printed her.
Judge, I do have an update for you whenever on Mr. Defendant's case for next week.
On whose?
Be behind, Mr. Defendant from yesterday,
Oh.
the one you allowed me to make the phone call.
Oh, good, good.
It's on stage and felony.
Okay. Good morning. Are you Keisha Lewis?
Yes. Judge, may I just ask the court two things before we proceed?
Yeah.
Can I make an oral motion to amend counts 1 through 4 in each motion to reflect committed the offense rather than arrested? We have discussed that upstairs, and everything that's been filed subsequently is correct.
Okay.
So I think
It's, if y'all catch them ahead of time, it's much easier for y'all to do it than me to try to do it on this computer. But yes, any objection to that, in each of the cases are the same?
No objection.
All right, let me get these printed out. It'll be easier. Sorry, it's taking me just a minute.
And Judge, also it is my intention, if the court follows this agreement, to have her plea to all 4 of those misdemeanors down the hall so that we can use them in the future for any enhancement purposes, and also to let you know I've spoken with her probation officer, Mr. Alex Hill, and he informs me that her case in Galveston County, the interfering with an emergency service animal, she did plead guilty to that, and they sentenced her to 1 year.
Thank you. 2 motions. Thanks. Okay. Let me make these amendments first. And thank you for talking to them and getting these changed. All right, let me. Today's the 3rd.
Some of it may have been just a misunderstanding for privacy.
Okay, now, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. Lewis, in cause number 22-40529, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the 2nd-degree felony offense of robbery, and that was a 7-year deferred probation. Is that correct? I'm sorry?
It was a 6-year probation.
hold on, I'll go back and double check.
It's not just 7, right?
Administrative hearing shows 7.
The deferred adjudication order dated January 25th of 2023 also shows 7 years. All right, so, you were placed on probation January 25th of 2023 for robbery, correct? Okay. And in cause number 22-40528, looks like there is a first amended motion to revoke your unadjudicated probation in that case. Shows you were placed on probation January 25th of 2023 for assault on a peace officer, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Should I have a first amendment in each of these? Did I? Hold on a second. 5, 2, 9. Yeah, hold on. Let me, I printed out the wrong thing. Sorry.
But all the amendment added was that case in Galveston. That's already been disposed of.
Okay. Just want to make sure. It just lines up the numbers better if I have them both, the right ones. I need that motion there just printed, please. Each of these cases, looks like the state is going to proceed on counts 1 through 6 in each of these cases. Count 1 in each of your cases, or in each of the motions, alleges that you committed the new offense of evading arrest or detention March 12th of 2025 in Jefferson County, Texas. And is that true or not true? I'm sorry?
True.
And then count 2 in each case alleges that you committed the offense of resisting arrest, search, or transport March 12th of 2025. And is that true or not true?
True.
Count 3 in each case alleges that you committed the offense of theft of property March 12th of 2025 in Jefferson County. And is that true or not true?
True.
And then count 4 in each case alleges that you committed the offense of failure to identify or giving false or fictitious information. And is that true or not true? That's also on March 12th of 2025. And that's true as well?
Yes, ma'am.
Count 5 in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 6 in each case alleges that you failed to provide verification of entering and successfully completing the anger management program. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Right.
I have here on the tablet in each of your case some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Lewis is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, and cause number 22-40529, find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-40528, also find counts 1 through 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certification in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.
The hearing ends with a negotiated prison sentence, but notice one important detail. The sentences run concurrently, not consecutively. That means the defendant serves both 4-year terms at the same time rather than back-to-back. It's a powerful reminder that plea agreements often shape the outcome long before a jury ever enters the courtroom, and understanding those negotiations is one of the most important parts of following cases like this.